This is an application made by the petitioner, Haki, in which application, my lady, we have put appeal ousting the jurisdiction of this court on various grounds, which are set out in the appeal. And my lady, since our preliminary objection speaks into the authority and jurisdiction of this court, we'll move that the same be given priority, be heard in the first instance. And I wish to confirm that we are actually ready with our submissions if the court do direct that we proceed to file. I've seen that the matter was filed under certificate by the petitioner, and therefore, if the court would allow us 7 days to have our submissions in place and allow councils to have their response, rather submissions on the same, or response thereof, within 7 days, then we can have the matter mentioned after 14 days for a ruling or a mention date, or further directions as the court so wishes.
My lady, indeed, what is coming up for hearing is the application dated 14th September 2023. My lady, this is a matter that was certified urgent, going to the actions, the impugned actions that were undertaken by the respondents. And as such, I believe that canvassing the PO, which my lady have gone through on the face of it, it's a PO which is basically listing factual issue. I believe my lady it would be in the best interest, as my client is suffering prejudice. My client is suffering loss of business owing to the impugned actions of the respondents. As such, I'll be praying, if indeed we have to canvass the PO, let us simultaneously canvass the application. In the interim, my lady, I'll be equally praying for a prayer number 4 of the application. There would be no prejudice at all that would be occasioned on the respondent by grant of prayer number 4 of the application. The petition has been operating the business of manufacturing alcohol since 2002. And as such, I believe there is no prejudice that will be occasioned. Whereas prejudice would be occasioned on the petition applicant if the orders sought are not granted.
My lady, what's before you is actually a judicial review application which is clothed seemingly as a constitutional petition. My lady, based on the prevailing rules under the Mutunga rules, equally with the precedents laid for this court in various matters that this court has had an opportunity to address itself to issues constitutional and issues judicial review. My lady, the application, the notice of motion filed by the petitioner does not lay out a claim of public interest that may interest this court to protect. It is actually equally defective in form, structure, and context. And the specific prayer number 4 sought by my learned colleague here my lady, is incapable of being executed against the county government or the respondents, and therefore cannot be granted. It is not true that the respondent will not have any prejudice if any orders are granted. The correct position is that the law is clear on how to undertake the process of licensing of alcohol, and it is the interest of public that the county government takes its duty and mandate to protect the public from consuming brews that are questionable, made without approval, and posing health issues and challenges to the public. My lady will seek that the matters as we are conversing now be addressed in submissions by both the applicant and ourselves, when the court will have an opportunity to address itself to the substantive issues of motions presented by both parties by the ruling. My lady, it could also be at this opportune time proper to inform the court that there is a continuing criminal matter filed by the public against the applicant in criminal case number E461 of 2023, E461 of 2023 before the subordinate court here in Chuka, which substantially is handling the same issues that this petition raises, my lady. It is a clear rule that issues of sub judice, my lady, oust a jurisdiction of a court, and therefore the claim that ours is an appeal based on factual issues is actually not the correct position. We seek that with your direction, that this court be pleased to direct that we file a submission and have a ruling date on the question raised in our preliminary objections.
May I read a brief rejoinder?
My lady, does he have a right of response on that?
How's the applicant, my lady? Yes, my lady, on the issue of judicial review, my lady, the petitioner here is seeking a declaratory order to the effect that his constitutional rights were infringed upon. The right to legitimate expectation and abuse of power, the right to a fair administrative action, the freedom from discrimination, the right to a fair hearing, the non-compliance with the statutory law. As such, this petition as it is before this court, it's proper before this court, the Honorable Court. My lady, on the issue of the criminal matter, where a party is raising an issue of infringement of their constitutional right, one cannot claim such judice. There is another pending criminal matter. Article 22, it's very clear on that issue. As such, I will belabor and I will beseech the court. Grant us prayer number 4. The petitioner is suffering loss of business. The petitioner is being harassed by the respondent. As such, I will beseech the court, grant us prayer number 4. We ventilate the issue of the PO and the application simultaneously. I will humbly pray.
maybe even before I give the directions, this PO is incomplete. I don't know how many pages you have, because you have only tried a page, a single page.
Well, what we have as a notice of appointment is a PO. You're saying that you're missing one page?
I'm only having this,
No, we have it
which simply states that you raise a PO, but the PO is not there. Has it been served?
yeah, it's resolved.
The issues which have been raised. And although I had certified the application as urgent, it is right that once the issue of jurisdiction is raised, it has to be determined first, as the court has to be sure that it has authority to take one more step in the matter. I would therefore direct that the preliminary objection be heard as a matter of urgency before the court can issue orders in the notice of motion. And I therefore direct as follows. The respondent will file and serve the written submissions on the applicants within 4 days, and the applicant to file their submissions within 4 days of service. The matter shall then be mentioned for the court to give a date for the ruling.
Maybe you can take the pen. Can take the 11.
So mention on 11th of this month.